Present in the case of State of Ohio versus Aretha Fitzgerald, 25 CR44. The defendant is present with counsel Rachel Smith. We're here today for the purposes of the sentencing hearing. The defendant does have 1 day of jail time credit. Thank you.
Ms. Smith, any reason not to go forward with sentencing?
There's none that I'm aware of, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor, if it pleases the court. Ms. Fitzgerald is before the court today, having accepted responsibility by way of pleading guilty to information and waiving grand jury presentment. She has been on bond for the pendency of this matter without issue and provided 2 drug screens, both of which were negative. Ms. Fitzgerald is 56 years old. She's married, has been married to her current husband for approximately 8 years. She has 4 children, 4 grandchildren. She's a high school graduate, has attended some college, and is a homeowner in the city of Richmond Heights, where she and her husband have lived for 6 years. She is employed as a full-time as a paralegal and has minimal criminal history. Ms. Fitzgerald has 2 prior convictions, both of which were misdemeanors, the first in 1988, the most recent being in 1994, save for this case. Ms. Fitzgerald has no history of drug and alcohol addiction, no known mental health issues, and per the pre-sentence report, it suggests a low risk of recidivism. Based on those factors, Your Honor, we do believe that Ms. Fitzgerald is amenable to community control. We would ask the court to impose a period of community control to allow Ms. Fitzgerald to continue working and to pay both the restitution in this case as well as the interrelated civil judgment that exists, Your Honor.
Thank you. Ms. Fitzgerald, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes. Thank you, Your Honor. First, I would like to express my deepest remorse and regret for my actions towards the estate of Robert Charles Scott, Madeline Wilby, and also Sheriff Thomas Law. I know I have caused, I understand that my actions were unacceptable. I take full responsibility for my actions, and I am committed to making amends for it. I showed a serious lack of judgment in my actions. When I first did it, it was to cover an error that I had made in an account.
Now you need to explain that to me, because for the life of me, I can't figure out how writing $60-some thousand worth of checks payable to you covers an error.
No.
I can't figure it out.
I'm saying when I first did it, it was to cover an error.
Explain that to me.
There was another account that did not have anything to do with this account.
Okay.
The person's check had bounced. I didn't bring it to the attention of Sheriff Thomas like I should have. So, because it was my mistake. And
what was your mistake?
The account of the other case that I messed up.
What'd you do?
The numbers came off. It was like it was more given to someone else, to another entity, as opposed to paying the fiduciary. Okay. So when he went to go cash his check bounced. So I covered. So
how does writing a check payable to you cover that?
Because I then took the money and put it into his account so it would cover his check. So that's what I did the first time. Now after that, yes, the rest of it, yes, it was used for my benefit.
You didn't admit that at all when you were at the probation department. You said all of this was to cover.
No, I said it was to cover it. I didn't go into the specifics of it. I said it was to cover an account, an error that I made on an account. I didn't go into the specifics of what the error was.
So you were short on one account, so you wrote a check on this account to get the money to put back in that account?
Yes.
Well then, this account that you wrote the check on was going to be short, right?
Yes. It would have been short. And it was my intent to, however I was going to do it, I don't know, but my intent was always to cover whatever it was that I had took out of that account. And then, like I said, it just snowballed.
Go ahead, continue.
Okay, and like I was saying, that my actions, they resulted, it got out of control. And of course, it was eventually found out what happened. And like I said, my actions have resulted in loss of my job. I cannot describe the regret and the embarrassment that I have for what I've done. So I went to a very dark place where I didn't even want it to exist anymore. But just talking it over with my family and friends, I'm able to get back on track again. And I just want to please ask the court that Sheriff Thomas, the state of Robert Charles, accept my apologies, and hopefully I'll be able to make the restitution to pay off what else is owed.
Thank you.
Yes.
Ms. Smith, anything else?
Nothing to add at this time, Your Honor.
Ms. Tuttle for the State of Ohio?
Thank you, Your Honor. First, Patricia Schraff is present and would like to make a statement.
Okay, we can hear from Ms. Schrapp at this time. You can just stand right there, spell your last name and state your name for the record here, then take your time and say what you want me to know.
Patricia J. Schraff, it's SCHRAFF as in Frank.
Thank you.
Judge, what I would like you to know, and the other members of our firm, is that Aretha was very well liked and very well regarded at our firm, and we were very much surprised by what happened. That being said, however, we are very concerned that this was an elderly person who was taken advantage of at an elder law firm, and that subsequent to Aretha's departure, she tried to get, and actually was successful in getting a job at another probate elder law firm where something like this could happen again. I think the needing assurances that this will never happen again to anybody else is very important. I've been in practice 45 years. I have never had anything like this happen. We're very disappointed in Aretha and very sad for her as well.
Thank you.
Thank you.
Ms. Tuttle?
She used her position as a paralegal to gain access to these client funds. She violated the trust of her employer by forging their signature, and she violated her duty to the client. The firm, as Ms. Schraff said, really liked her. They really trusted her, and this really hurt their business, and it hurt the client. Ms. Fitzgerald wrote 8 separate checks to herself. She forged partner John Thomas's signature on each of those, and then cashed those checks in her personal bank account. It wasn't a mistaken transfer. It wasn't an error. It was a calculated process. She wrote herself $62,900 in checks from money that belonged to Madeline Wilby and used that to live her own life. From March to June, the defendant was spending over $20,000 a month from her own bank account. She was shopping at luxury stores such as Louis Vuitton and Coach, spending hundreds of dollars at Morton's Steakhouse. She was getting regular massages, buying tickets to the Las Vegas Raiders, spending hundreds of dollars on merchandise at the Cavs team store. She was using this money to live her life in a way that she wanted. The conduct is inexcusable. The defendant does have 2 prior convictions, those being for a misdemeanor assault in 1988 and a misdemeanor theft and falsification in 1994. We're also requesting restitution in the amount of $1,000 to be paid to Schraff Thomas Law Firm. All other monetary loss was handled by their insurance carrier. Additionally, there is a civil judgment in effect through Judge Ruppel's court for 3 times the amount of the loss, as the defendant did not appear for her default judgment hearing. Thank you.
This court reviewed the pre-sentence report and investigation and considered the victim impact statements that were received. I've considered the facts and circumstances of this offense, the nature of the offense, and the defendant's conduct. We've considered what's been said here today in court by the defendant herself, her lawyer, the prosecutor, the victim impact statement made here in court. All this is considered by the court by the purposes and principles of felony sentencing set forth in 292911. Factors indicating the conduct is more or less serious. In regards to being more serious, the court finds that the defendant used her position of trust in this law firm to facilitate the commission of this offense. Victim suffered serious economic harm, and the victim being was the estate of an 80-year-old woman. The injury exacerbated due to the age of the victim. These are all factors indicating Plus, quite frankly, just the criminal intent involved here. This wasn't just a one-time isolated incident where she stole something. This was heard over a lengthy period of time on multiple occasions. So it was well thought out, maybe well planned. Every time that you did this was a separate offense, quite frankly. It was so the criminal intent is something that was ongoing and lasting for a substantial period of time, which is different from any thefts that we have, where it's just you go in, you take something, or it takes them for some person. It's a one-time incident. Nothing makes this less serious. As for recidivism factors, the court does note the defendant has 2 prior misdemeanor convictions, albeit it's, math right, 30 years ago, I think. A substantial time ago. Defendant certainly, at the probation department at least, minimized her conduct here, made it seem like she had to cover up some error that she committed. So she was writing checks to herself to do that. It just made no sense, her story. Now, she cleared it up here a little bit today, acknowledging that the first time she did it, that was the case, and then I can only presume she realized it was easy to do and decided to start doing it herself to the tune of $69,000, $64,000?
$62,900.
$62,900. Using the money to just live a lavish lifestyle. Factors indicating recidivism is less likely. The court finds the defendant has led a law-abiding life for a significant number of years. Again, he has the 2 prior misdemeanor convictions, but the last was, it was 30 years ago. So in the past 30 years, there's been nothing. Count 1 is a felony of the 3rd degree, which does not carry any presumptions either way for prison or community control sanctions. You can easily find here that prison is consistent with the purposes and principles of sentencing based on the nature of the conduct and the amount of money involved. And we find at this time the defendant, however, is amenable to community control sanctions. I'm going to put the defendant on community control sanctions for a period of 2 years. There are going to be consequences, however. You're going to serve 150 days in the Lake County Jail. It's credit for 1 day you've served. Further conditions, you are not to be employed by any law firm or any lawyer at all during your period of probation, at least. You're to obtain and maintain full-time employment, but that, again, should not be for a law firm or a lawyer or any legal practice. Not to use any drugs or alcohol. Urine screens have to be negative. To perform 100 hours of community service, pay your court costs and supervision fees, pay restitution to the Sheriff Thomas Law Firm in the amount of $1,000. Not to make contact with the law firm, Sheriff Thomas Law Firm. If I find out you're doing any legal work once you're done serving the jail sentence, you're going to get violated and go to prison. You understand that?
Yes, Your Honor.
So I said no employment by a law firm or lawyer, and I don't want you searching for some type of loophole in what I said. You're not to do any legal work. All right?
Yes, Your Honor.
And that covers everything. Ms. Pell, is there anything else that I omitted or we should address?
No, Your Honor.
Ms. Smith,
Not on behalf of Ms. Fitzgerald, Your Honor.
thank you.
All right.